acquiring an Indian business is absolutely possible. The acquisition of an Indian business follows familiar international principles, but with a distinct Indian twist at almost every step. In Indian M&A, understanding the difference between price and value and doing the diligence to know which one you are getting is everything. Hello and welcome back to the Veyrah Law series. In this episode, we look at something that sits at the heart of M&A practice in India: acquiring an Indian business. It does not matter if you are a strategic investor buying a local competitor or a financial investor taking a controlling stake. The acquisition of an Indian business follows familiar international principles, but with a distinct Indian twist at almost every step. Let us start with the framework. Most methods common in international markets are available in India. A share purchase is the most common. You buy the shares of an Indian company, you step into the shoes of the seller. Simple in concept. A share swap is also possible, issuing shares in the acquirer to the seller in exchange for shares in the target. But this is subject to fair market value rules if the seller is an Indian resident. We will deal with this point shortly. Next, the slump sale is another option. It is the acquisition of an entire business undertaking, assets, liabilities, contracts, employees as a going concern for a lump sum consideration. The slump sale is an efficient mechanism because it is a private contract between two Indian parties. It allows the acquirer to avoid legacy liabilities of a business. Secondly, it avoids the FMV restrictions that apply to share transfers between foreign buyers and Indian sellers. How? Structure it as a transfer of the target business into a foreign-owned Indian company. The transfer of a business as a whole happens domestically. FMV restrictions do not bite. You own the business through your Indian entity. For asset-light businesses, software, IP brands, a slump sale into an offshore entity is theoretically possible, but we normally advise against it. Employment agreements, tax consequences, and FEMA compliance make this complicated and rarely worth the effort. Acquisition through inbound reverse mergers are permissible. A foreign acquirer company merging into an Indian company. There are some nuances, but it is definitely possible. But it would require approval by the relevant company law tribunal in India. This method can be time-consuming if time is of essence. Next, you could do outbound mergers. An Indian company merging into a foreign company is technically permitted, but not yet fully functional in practice. The mechanics remain untested at scale. With many complexities involved in the post-merger compliances under Indian exchange control law. Now, let us address the two restrictions that catch most foreign acquirers off guard. First, the FMV restriction. Under Indian exchange control law, a foreign buyer acquiring shares from an Indian resident must pay at least fair market value. This is not negotiable. You cannot agree to a price below FMV with the Indian seller. Why does this matter? In Western M&A, buyers often structure a portion of consideration as contingent, tied to post-closing performance. In India, the FMV floor means the seller must receive at least FMV at the time of transfer. You cannot simply hold back a large portion pending future outcomes. Second, the 25% holdback limit. Indian exchange control rules permit a maximum of 25% of total consideration to be deferred or held back, but that too only for a limited period. This severely restricts classic Western deal protections, escrow arrangements, earnout structures, warranty holdbacks. You are working within a tight box. 25% maximum for a limited time. That is it. To be honest, there are ways of structuring around each of these restrictions, but that's a topic for a detailed discussion for another time. So then, how do sophisticated acquirers navigate the acquisition regime in India? Here is what we would recommend at a high level, without getting into structuring details. First, thorough diligence is your only real protection. The next statement might come as a surprise to some dealmakers who spend hours negotiating indemnity clauses. Indemnities in Indian acquisitions are largely theoretical. Let me repeat that again. Indemnities in Indian acquisitions are largely theoretical. As we discussed in earlier episodes, Indian courts are slow. Enforcement of indemnity claims is expensive and uncertain. It does not matter if it's a foreign arbitral award or a domestic arbitral award. The seller's ability to pay a large indemnity claim may not exist by the time you win or enforce the award in India. Your real protection is finding the problems before you close. Thorough legal due diligence, thorough financial due diligence, tax diligence, and critically, promoter diligence. The promoter's history, how they have treated past investors and creditors, is a strong indicator of how post-deal life will feel. Be willing to walk away from a bad deal. No deal is better than a bad deal. Second, structure earnouts and holdbacks inside India. The 25% holdback limit is a real constraint. But there is a workable solution. Structure your earnout and deferred consideration inside the Indian entity, not as a cross-border holdback. The Indian target that owns the business can hold back funds internally, payable to the seller upon satisfaction of agreed milestones. This avoids the FEMA holdback limits on cross-border payments while still giving you meaningful performance protection. Tax advice is essential here. The mechanics must be structured to avoid unfavorable tax treatment on the deferred payments. Third, consider warranty and indemnity insurance. Warranty and indemnity insurance is available for most Indian M&A transactions. It provides the buyer with a direct insurance claim against warranty breaches instead of relying on the seller's covenant to pay. This is particularly valuable in India because it removes your dependence on the seller being willing and able to honor a claim. Warranty and indemnity insurance is growing in India. Premiums have come down. Coverage has generally improved. For mid-sized to large acquisitions, it can now be increasingly considered as a protection layer. Fourth, tax drives structure. Respect GAAR. A large part of acquisition structuring in India is tax-driven. The choice between share purchase and slump sale has different tax consequences for both buyer and seller. Capital gains for the seller, stamp duty and GST implications for the buyer. Get specialist tax advice before you settle on a structure. And be mindful of GAAR. As the Tiger Global judgment confirmed, structures designed primarily for tax efficiency without genuine substance will be challenged. The tax saving must never drive the structure to the point where substance is compromised. Fifth, avoid deals with messy regulatory history. This is a point that experienced India acquirers know well. Historic regulatory litigation, pending tax demands, environmental notices, ownership disputes do not disappear when you close the deal. You inherit it. Indian regulators are diligent about pursuing historic violations against successor entities. The cost of cleaning up regulatory history post-acquisition can be substantial in money, time, and management attention. Price it into the deal or walk away. To sum up, acquiring an Indian business is absolutely possible. The tools are there: share purchase, slump sale, inbound reverse merger. But the Indian twist is real at every step. Fair market value pricing is non-negotiable. Holdback is capped at 25%. Indemnities are largely theoretical. Tax drives structure. Regulatory history travels with the deal. The acquirers who succeed do their diligence thoroughly, structure creatively within the rules, and are never afraid to walk away. India's M&A market is maturing rapidly. Transaction volumes are growing. Valuation benchmarks are clearer. The regulatory framework is becoming more friendly. The direction of travel is right. But as Warren Buffett once said, price is what you pay, value is what you get. In Indian M&A, understanding the difference between price and value and doing the diligence to know which one you are getting is everything. We hope this episode has given you a useful framework for acquisitions in India. If you found this video useful, please do share it. Thank you for watching and see you in the next episode.